The final full week of the Supreme Court's term kicks off tomorrow, and it's coming down to the wire with the 11 cases still outstanding. So let's talk about some of the big headliners with Elizabeth Wydra, Chief Counsel at the Constitutional Accountability Center, and Tom Dupree, former Deputy Assistant Attorney General. I now convene the meeting of the SCOTUS Nerds Club. This is our favorite time of year. It's very exciting. And these decisions will have wide-ranging impacts. So let's talk about a couple of them. Let's start with Hobby Lobby. This is the one that's getting a lot of ink this term, and it deals with the administration's HHS contraception mandate, part of the Affordable Care Act. Essentially, employers who provide insurance to their employees have to make sure that includes cost-free access to 20 different contraceptives. The family that owns Hobby Lobby, devoutly religious, and they say there are 4 of them they believe can act as abortifacients. So they object to those. They have religious objections and others. It was a really good case when it was argued. I mean, Tom, what's at stake here? Are we talking about religious freedom, freedom of speech? What are we watching for?
It's primarily religious freedom, Shannon, and this is, as you say, a fascinating case in that we already saw major litigation over Obamacare several years ago, and many people think, with some reason, that Obamacare is a massive infringement on our freedoms and liberties, and that this is just one of the aspects in which the statute really does infringe on religious freedoms. And you have a situation where employers have basically said, look, being forced to provide this sort of coverage violates my most profound, fundamental religious beliefs. And so what the Supreme Court is wrestling with is, well, what is the state interest? Can we carve out an exception that allows the vast majority of the requirements under Obamacare to remain in effect, but to carve out a sphere of safety for people who have profound religious objections to providing the coverage that's mandated? So we'll see what the Supreme Court does. Again, it's not a challenge to all of Obamacare, but it's a challenge to a very significant aspect that means a lot to a lot of people.
And Elizabeth, there are those who have said, you know, it's a corporation. A corporation can't have religious convictions, and if you allow an employer to use a conviction for this, they'll object to other things. You know, and they're really talking about the slippery slope. I mean, what's your take?
Yeah, so what Hobby Lobby is asking the Supreme Court to do in this case is really unprecedented. Never in our nation's history have corporate for-profit entities been understood to share in the protections for religious free exercise that living, breathing human beings have. You know, this has been understood to be a right of conscience, something deeply personal that individual living, breathing human beings have, but artificial corporate entities wouldn't. And, you know, I think it's important to see the slippery slope here when you think about, you know, 2/3 of Americans consider ourselves to be religious people. And if we have a business, a corporation, whether it's Walmart or an airliner or a craft store, just because we ourselves might be religious in our personal lives doesn't mean that we can imbue this artificial corporate entity with those beliefs and be treated like a church or other explicitly religious organization when we enter the business field, especially when you're talking about the rights of employees across the country, in this case, the tens of thousands of female employees of Hobby Lobby who are statutorily entitled to the full range of FDA-approved contraception.
Okay, I won't ask you to commit to a prediction. I will just ask you, do you think this is a 5-4 decision, or do you think there'll be a broader split?
Well, I'll take a crack at that one. My sense is it probably will be 5-4, and I'll go even further, and I'll say that let's look at Justice Kennedy, what he has to say.
Surprise.
Going way out on a limb here, but he often holds the trump card, as we SCOTUS nerds know, in these hotly contested constitutional religious freedom cases. So we'll see what happens, but you won't go wrong keeping an eye on Justice Kennedy.
Of course. You say 5-4 also, you think?
I think it might be close. You know, I think that the justices really have to think closely about whether they want to go out and take this unprecedented step, and something that is new when it comes to constitutional text and history.
All right, I want to quickly get us through a couple more cases. We also have the case involving the president's appointment of members to the NLRB, the National Labor Relations Board. Very important appointments. Members of the Senate, many of them say, we were in recess, you didn't have the power to appoint them. What does the court decide?
So this is a really interesting case for people who are interested in con law, you know, the Supreme Court con law nerds like us.
Power,
yeah, but also
power.
It's a case that the Supreme Court has never really decided this sort of issue before, and the framers put the recess appointments power into the Constitution to ensure that the president, who's on duty 24/7, could make sure that the government is functioning and be able to put in officers and judges in some cases to these positions while the Senate is off in recess, because they're not on the job 24/7. And, you know, it's interesting that it's been framed as sort of this partisan fight against the Obama administration, when it really shouldn't be a partisan issue, because presidents from going back to George Washington have used this power, and more recently George W. Bush, Ronald Reagan, as well as Clinton and President Obama have used this power. So I think it'll be interesting to see what the court does here, whether they craft a more narrow ruling or go with the very broad, novel approach taken by the lower court.
Tom, what do you think? Because a lot of folks that I talked to and I sat through the arguments think this may not go well for the executive branch this time around. We'll see.
Well, certainly, if you look at the questions that the justices were asking in argument, they were expressing deep skepticism about the administration's position. It does seem, at least to me, self-evident that what the president was trying to do here was to do an end run around not just the Senate, but also an end run around the Constitution. I think the Constitution is pretty clear that you cannot do what the president tried to do here. And if, particularly in a case like this, where the Senate itself has said that it's not in recess, for the president to essentially unilaterally determine, contrary to the Senate's judgment, that it is in recess and force these appointments through, I think is wrong and unconstitutional.
Been a lot of clashing of the branches in recent years. So we'll see where the court, yet another branch, comes down between these two branches. We could talk about the 9 others, but, you know, we're out of time. I'll see you guys over the court this week.
Absolutely.
10 o'clock tomorrow morning. All right. Thank you both.
Thanks, Shannon.
Great to be here.